As the SEC versus Ripple case is going on, there are new ongoing cases which could indicate a close ending of the court case. Will that happen? And what new news are there on the XRP Ether controversy? Stay tuned till the end of the video to find out. But first, we are giving away 50 XRP coins at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comment section. Welcome back XRP Army. Several members of the XRP community had anticipated that the next court update would come around the 19th of January when the SEC versus Ripple Labs litigation entered its second year in 2022. Following the publication of the SEC most recent file, crypto observers were in for a pleasant surprise, as the document takes aim at one of the foundational pillars of Ripple's case. The Fife case was a dispute between the Securities and Exchange Commission and the defendant, John M. Fife, and his 5 businesses. The SEC highlighted the following in its filing. Fife case rejected, at the pleading stage, the same fair notice argument Ripple asserts in this case and that the SEC has moved to strike. The document goes on to state, indeed, Fife rejected the defendant's fair notice defense at the motion to dismiss stage despite acknowledging the lack of binding authority, construing the term dealer. In Ripple's case, binding authority construing the term investment contract has existed since 1946. W.J. Howie Co. Fife provides additional authority for striking Ripple's fourth affirmative defense. The SEC versus Ripple lawsuit, according to industry insiders and media influencers, is considerably more than simply another tiresome court fight. Even more alarmingly, some predict that the final decision would alter crypto policy in the United States. This could either encourage fintech innovation in the nation or force domestic firms to relocate to foreign countries. According to business journalist Charles Gasparino, the case has the potential to be the biggest story in cryptocurrency by the year 2022. The outcome of the case will also have an immediate impact on the tens of thousands of XRP holders whose assets have been blocked or delisted as a result of events they think are connected to the ongoing litigation. Comment, XRP Army, if you believe Ripple will win the case soon. The SEC case has also seen much more breaking information. For the purpose of supporting its request to strike Ripple's fourth affirmative defense, which is the fair notice argument, the Securities and Exchange Commission has submitted a letter of supplementary authority. As stated in the letter, the Fife defendants asserted that they were not given adequate notice of the SEC innovative interpretation of the statutory word dealer. By the way, did you know about this news? Let us know in the comment section down below. Although the court agreed that, for the purposes of assessing fair notice and due process, the standard against which the SEC seeks to measure defendants' conduct is the statute itself, the court sided with the SEC, noting that the language of the statute, of which defendants and all others even arguably involved in securities transactions plainly have had notice, is the standard against which defendants' conduct is measured. It is expected that the SEC would use the same reasoning in SEC versus Ripple. It is for the courts, not the parties, to determine whether particular conduct falls within or outside the scope of the statute. As a matter of fact, even while the court acknowledged the lack of binding authority in the construction of the term dealer, the court rejected the defendants' fair notice defense when they filed their petition to dismiss. In Ripple's instance, there has been a binding authority construing the word investment contract since 1946. While Ripple Labs works on a response to the SEC letter, XRP community attorney Jeremy Hogan took to Twitter to provide his thoughts on the matter, which he believes marginally strengthens the SEC position in its motion to strike Ripple's fair notice defense. It was at a very different stage of the lawsuit, and the standard was fundamentally different than in the SEC versus Ripple case, he explained. In the Fife case, the defendant attempted to invoke the doctrine of fair notice and try to have the complaint dismissed outright, but was unsuccessful, because the standard of proof on a party seeking to strike a pleading is extremely high. After everything is said and done, Fife can still bring it as an affirmative defense in the future, and I anticipate them to. In the Ripple case, it's the SEC that is trying to strike the affirmative defense of fair notice and it has the high burden to meet. The general idea in modern courts is that the decision should be made after looking at the evidence, unless there's no plausible way of winning, he explained. However, one of the most contentious issues continues to be the fact that the SEC classifies XRP as a security, but for some reason does not classify Ether as such. Is this going to change now? When Gary Gensler was a professor at the Massachusetts Institute of Technology, he contended in 2018 that Ether's developers broke federal law when they distributed $18 million in tokens without registering them as securities with the Securities and Exchange Commission. Do you agree that Ether should be labeled a security as well if XRP is one? If yes, then make sure to like this video. Today, as chairman of the Securities and Exchange Commission, Gensler will not say whether he has changed his mind about cryptocurrencies, or whether he believes that the second most valuable cryptocurrency after Bitcoin is still a security. A question whose answer could have far-reaching implications for the entire crypto economy, including massive exchanges like Coinbase Coin and FTX. According to Gensler, who spoke with CNBC on Monday, "I'm not going to speak to any specific matter." He was responding to the question of whether or not he believes Ether is a security. In addition to serving as a civil law enforcement agency, I serve as the head of the Civilian Law Enforcement Commission. We do not participate in these types of public forums where we can discuss any one project or possible circumstance and provide legal advice over the airwaves, I said. He has previously stated that he believes that U.S. securities legislation and case law make it apparent which digital assets are securities, and that the vast majority of currently available crypto tokens are being provided to the general public in violation of the law. The Howey test, which states that an instrument is considered a security when it is a contract, transaction, or scheme whereby a person invests his money in a common enterprise, and is led to expect profits solely from the efforts of the promoter or a third party, is an important set of criteria for determining whether an asset is a security in the eyes of the law. Regarding cryptocurrencies, the pertinent question is whether or not they truly constitute a common enterprise. Bitcoin BTC USD, 0.06% and Ether creators, according to William Hinman, a former director of the Securities and Exchange Commission's Division of Corporate Finance, did not have adequate control over their currencies to match this criterion in a speech in 2018. However, this speech does not constitute formal advice, and Hinman is no longer employed by the SEC. The ongoing SEC legal action against Ripple Labs Inc. and two of its executives, who are the issuers of the cryptocurrency XRP, has brought the dispute over whether Ether should be deemed a security to the forefront of the public's attention. When the SEC filed litigation against Ripple, the company responded by stating that there is no principal distinction between its current function and that of Bitcoin or Ether. Because Gensler, a Democrat, has refused requests for clarification on why the SEC considers XRP a security, as opposed to other digital currencies such as Bitcoin or Ether, this lack of clarity has enraged crypto supporters as well as the two Republican commissioners on the five-member SEC Board of Directors. What do you think about this news? Do you think the SEC will correct its stance on XRP and Ether? Let us know in the comment section. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.